All right, are you Shadamon Mitchell? And will your client waive the formal reading of the indictment?
She will.
The judge jumps straight into procedure, no warm-up, no easing in. This is classic arraignment energy, fast, formal, and meant to set the tone. Notice how the defense waives the formal reading? That's basically them saying, yep, we've read the charges, let's get to the real stuff. It saves time but also signals they're prepared.
Ms. Mitchell, in cause number 24, DCCR 2270, you're charged with the state jail felony offense of theft of property from August 11th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes,
And are you pleading guilty because you actually did what they've charged you with?
yes.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Comerford?
Yes,
Do you fully understand them?
yes,
And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal?
yes, sir.
And it looks like the agreement that you've reached is for a 3-year deferred probation. Looks like y'all agreed to a $500 fine, but there's also almost $4,000 of restitution.
Yes, sir.
Okay.
Here's where things get spicy. Restitution isn't a fine, it's payback for the actual financial damage. And when a judge says, I'm inclined to reduce that fine, what they're really saying is, I'd rather you repay the victim than pay the government. It's a subtle shift, but a huge legal win for the defendant.
But we're okay with it.
Inclined to reduce that. I'd much rather the restitution. How old are you?
25.
Okay.
We're okay.
So the restitution would be $3,999.68. Is that your understanding?
Yes, sir.
And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, sir.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, sir.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Mitchell is not competent?
There is not.
And is there any reason not to go forward today since y'all have the restitution
No,
amount?
the judge doesn't have a criminal history.
All right, so Ms. Mitchell, I'm going to find that you entered your plea of guilty freely and voluntarily. Find.
Whoa, pause right here. The judge instantly notices movement in the courtroom. This may look like a tiny moment, but it shows how alert judges are during pleas. One distraction, one unusual gesture, and they'll stop everything. Why? Because if a plea isn't 100% clear, voluntary, and focused, it can get overturned later.
I'm sorry, did you just do something? I'm seeing movement. I thought so.
I'm sorry.
That's okay. I thought she needed something on your case. All right.
I'm so sorry.
No, you're fine. I'm going to find sufficient evidence. I find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to waive the pre-sentence report. I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for a period of 3 years. I'm going to order a $250 fine, and I'm going to order that you pay restitution in the amount of $3,999.68 and follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have a felony conviction on your record. And if you successfully complete the probation, at the end, the case is actually dismissed. You will never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty, so you would be a convicted felon, and you could go to the state jail prison for up to 2 years. Do you understand?
Yes, sir.
So $4,000 is a lot of.
This is the classic I'm giving you a chance, don't waste it speech. Judges aren't just warning, they're documenting. Every caution she gives becomes part of the record. So if the defendant violates later, the judge can say, you were fully warned. It sounds emotional, but it's also strategic courtroom procedure.
Money for anyone, especially someone your age. And so it's very important to me that you start making payments on that immediately. even if it's $20 a month. Some people think, well, I'm going to wait and get my tax refund, or my family's going to help me out in 6 months, and all of a sudden you're at the end of 3 years. And if you haven't paid that restitution, and I find that you could have paid it, you could do everything else right on your probation, and I could still send you to prison. So I want you to make some payment every single month. It'll add up over that time. All right? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Also, do not ever show up in court with your midriff showing again.
I'm sorry.
I don't need to see your belly button in court.
Oh, yes, ma'am.
Okay? You're in felony court. Dress appropriately. That's important. It's time to kind of grow up.
And here's the real-world reality of felony court. Presentation matters. Judges don't expect designer suits, but they do expect respect for the room. The belly button call-out might seem harsh, but it's actually common. Image, attitude, and maturity all feed into how much trust the court gives you.
You're on a felony probation. You need to do things in an adult way, and dressing like that is not an adult way to show up to court. Okay? You need to have a seat here in the courtroom. Probation's going to call you to her desk. She's right over there. Watch for her to call your name, and then she'll go over your paperwork with you. Okay? Good luck to you, ma'am. Thank you, Mr. Comerford. Good morning.
Judge, we are winding down on this. We got an offer since our last court date.
Okay.
It has $80,000 in restitution. So what we're asking the court is give us a little bit more time to vet that, the proof of services for that, and see if that's something that we could come up with up front to help resolve a case. I did find, I looked and couldn't find them. I did find though the proof of services for that $80,000, so we need to go through it. He has
Okay.
not seen it. That was added in discovery at a later date than when he came to my office the first time.
Okay. Any issue?
No, if you recall, when we first came in here, we were still waiting for.
Right.
Because the cleanup was still.
Right. And so y'all got everything's here, you've got it all? Okay.
The offer's been sent, we should be.
Perfect.
Done today.
So we'll do one more reset, and Mr. Rucker, make sure you go in, visit with Mr. Galmore, go over all of that discovery so that we can figure out an announcement at your next court date, which direction your case is going to take. Okay? All right.
Judge.
Thank you.
And just like that, the judge shifts from compassion to business. Watch now. This is where every word starts to matter.
All right, his bond will be forfeited for non-appearance and reset at $100,000. He did call, say he was having issues. If he gets here late, then I'll obviously recall that bond forfeiture.
And Judge, like I
You've
said,
got Karis and, oh, go ahead, I'm sorry.
he did call this morning. When I tried to call him back to his house number, he was already gone, so I'm assuming he is trying to.
Maybe on his way. Okay, thank you. And then you've got Karis Antoine, Mr. Lewis.
Yes, ma'am, Judge.
Are we? Okay. You're Karis Antoine, and this is cause number 24 DCCR 1878. It looked like I did sign an order back in May for CPS records.
You did, Judge, and we contacted them this past week asking for an update. They hadn't gotten back with us yet.
Okay.
I even had Mr. Hoppower call because he's used to dealing with them.
Right.
And he did that for me at the end of the week, and they hadn't replied yet.
All right, we'll reset that just another 30 days. If you'll make a sticky note for us, we'll try to contact them as well and see if we can, sometimes that helps to get things moved
So
along.
reiterate what you said. I spoke to them by email, Stephanie.
Okay.
But we still haven't received those records.
And she didn't give any update on when we
She
could
didn't give me
expect
an
them?
update, But it was Friday.
Okay.
I got last contact.
She's usually pretty responsive.
Yes.
All right, so Mr. Antoine, stay in touch with Mr. Lewis. He'll let you know once he gets that information so you can go in and go over it with him. And then we'll try to get an announcement, hopefully if we get that before the next court date.
Thank you, Your Honor.
Thank you.
And off the record,
Good morning, Mr. Rojas.
Morning, Your Honor.
Good morning, sir. Are you Carnell Beard?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He will, Your Honor.
Are we going on count one? Oh, no?
No, ma'am.
Okay,
Everything.
okay, let me, All right, and he'll waive the formal reading of the indictment. Mr. Beard, you're charged with a third-degree felony offense of collision involving serious bodily injury from September 28th of 2024. Your indictment also alleges that you were previously convicted of attempted murder, second-degree felony, August 30th of 1999. And after that was final, you were convicted of possession of a controlled substance, a first-degree felony. Well,
Judge, I'm
do we
looking
just
at
need
the
to go on one, or
Let's
is
just
that?
go on one, because I'm looking at the dates, and they do overlap, so it would not make them
It
habitual.
wouldn't,
It'll
so it
be
makes it a second-degree felony.
Your Honor.
So what that means, sir, is that the punishment range in your case would be enhanced to that of a second-degree felony, which is between 2 to 20. Do you understand?
Yes, ma'am.
And how do you plead to that charge?
Yes.
And is that prior offense true?
Yes, ma'am.
Okay. Did you enter your plea of guilty and true freely and voluntarily?
Yes, ma'am.
Attorney, that you will be waiving or giving up any right to appeal.
Yes.
And it looks like the agreement that you've reached is for a 10-year deferred adjudicated probation. There would be a $1,000 fine, and there would be restitution ordered as determined between now and when we come back for pre-sentence, through a pre-sentence report. Is that your understanding?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Beard is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case. We'll also get that restitution amount determined, and then we'll come back later for sentencing. When you're on your way out of the courtroom today, you need to stop and talk to probation, and she's at that desk right there. All right, we'll see you back at sentencing.
Thank you, Your Honor.
Good morning, sir. Are you Zachary Turner?
Yes, ma'am.
And this is 24 DCCR 2197. And Mr. Turner, you're charged by indictment in this case with the first-degree felony offense of fraudulent use or possession of identifying information from April 22nd of 2024. Your indictment alleges that you were previously convicted of unlawful possession of a firearm by a felon, a third-degree felony, September 29th of 2014, which means that this, for punishment purposes, would be enhanced, but
1599 is the way we indicted, Judge.
right.
Given the rejection of the state's offer today, I believe we can make him a habitual, and I will be filing a habitual offender notice in this case.
So, and you've gone over that with Mr. Rojas, correct? And so I want to make sure you understand that if the state files that notice of enhancement with another prior offense, which I would assume you have since the one I see is an unlawful possession of a firearm by a felon, that means that if you go to trial and you're found guilty, the minimum punishment would be 25 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
And I have a plea bargain rejection here that has your signature on it with Mr. Rojas's that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, for a 15-year term in the institutional division of the Texas Department of Corrections. And I would assume that would be going on count 1 only.
That's right.
And so you have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that? And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get that done. Mr. Turner, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and I can appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? So, Mr. Rojas, you're released. Mr. Turner, if you'll just have a seat here in the courtroom, I will appoint someone. The clerks will call you up in just a minute with.
The transcript unfolds in a courtroom brimming with tension, where every gesture and word carries monumental consequences. The central figure, Miss Mitchell, faces a state jail felony for theft of property. The judge, exacting and watchful, ensures she comprehends the implications of a guilty plea, including a 3-year deferred probation, a $500 fine, and nearly $4,000 in restitution. Small courtroom motions catch the judge's attention, emphasizing the unforgiving precision of legal proceedings. Her probation offers a delicate lifeline, a chance to avoid a felony conviction if she follows every condition, yet any misstep could spell 2 years in state jail. Alongside Miss Mitchell, Karis Antoine and Carell Beard enter, their cases echoing similar themes of prior convictions, plea bargains, and suspended sentences. Each defendant must navigate complex legal terrain, weighing fines, restitution, and probation terms against potential imprisonment. The narrative crescendos with Zachary Turner, whose first-degree felony brings the looming specter of decades in prison. The judge meticulously explains habitual offender enhancements and plea rejections, underscoring the high stakes. Throughout, procedural rigor intersects with human vulnerability, the defendant's pasts, their financial and moral obligations, and the silent pressure of courtroom scrutiny all collide. Themes of accountability, choice, and redemption thread the stories together, creating a tense, cinematic tableau. Minor details, clothing, gestures, the order of testimony, reveal the subtle power dynamics shaping outcomes. By the transcript's end, viewers understand the full weight of these proceedings. The courtroom is more than a place of judgment, it is a stage where decisions echo far beyond its walls. Ultimately, it leaves a chilling reflection. In the realm of law, even the smallest misstep can alter a life forever, and every plea carries consequences that ripple outward, testing character, resolve, and